साधनाएं, कुसुमित नई कामनाएं, सुरभित नई साधनाएं। मैत्री मति क्रीड़ागण में प्रमुदित बंधु भावनाएं, मैत्री मति क्रीड़ागण में प्रमुदित बंधु भावनाएं। शाश्वत सुविकसित इति शुभम्, शाश्वत सुविकसित इति शुभम्। आनंद मंगल मंगलम्, आनंद मंगल मंगलम्। नित प्रियम् भारत भारतम्, नित प्रियम् भारत भारतम्, नित प्रियम् भारत भारतम्, नित प्रियम् भारत भारतम्।
Recording in progress.
A very good morning to all of you, all the dignitaries present, my dear students. A very good morning again. I welcome you on board of 3rd Maharishi Law School and Maharishi School of Business Management International Conference on labor laws, National Labor Law Association in association with, and the topic, as we know, we are standing on the second day of comparative labor laws in South Asia, labor and management perspective. So before we start with this working session, I would like to call on stage Dr. Smita Mishra ma'am and Professor S.C. Srivastava. Let's have a hand. We welcome you, Professor S.C. Srivastava, sir. On this second day, it's a great pleasure and honor to have you on board. Thank you, Tripti ma'am. Thank you, Dr. Srivastava, sir. Now I'd like to call Dr. Arpana Sharma on stage. And I would also like to call Dr. K.B. Asthana on stage to felicitate Dr. Arpana Sharma. Let's give them a big hand, please. Now I would like to call Dr. Lalit Kumar Sharma on stage, please. And I would again request Dr. Asthana to come on board and felicitate him. Thank you so much, Dr. Lalit Kumar Sharma. Now I'd like to call on stage Dr. Neelam Tyagi, ma'am. And I'd also like to call Dr. Archana Pandey, ma'am, to felicitate her. Can we have a big round of applause for both of them? Thank you, Neelam, ma'am. Thank you, Archana, ma'am. Now, again, I would like to call Trapti, ma'am, on board to felicitate Dr. Sunil Kumar Agarwal ji. Dr. Sunil Kumar Agarwal ji. Thank you, Tripti, ma'am. Thank you, sir. So, continuing with what we were discussing about the labor laws in South Asia market and all the in perspective of labor and management perspective, we'll be continuing that discussion today on the second day of this conference, of this international conference. And before we dive into the second day, I just want to have a glimpse of, I just want to discuss the glimpse of what actually we are discussing about those who have joined today itself. We're talking about the labor laws sort of with the management perspective in the South Asian market. See, we will be discussing a lot more about here in conferences, but the major issue is implementation of those issues. We can discuss a lot of things. We have dignitaries, we have authoritarian people who have number of ideas, but when it comes to implementation, that has to be more important. We have informal sectors, we have child labor and forced labor, we have labor exploitations going on in South Asian markets, especially in India, Pakistan, all the developing nations. We have contractual labors issues, and we have sort of enforcement challenges. That is the most challenging thing in the today's world, because you can always make laws, but when it comes to implementation, it goes down not so effectively as the motive was when it was made, when the law was made. So enforcement is the most important thing we have to talk about. Next is freedom of association, then occupational health and safety, the hazards every labor has to face while he's working in the in any of the occupation he's working in. So with that, I would like to start this working session, and Dr. Sthana would please. Okay, so I would like to call Dr. B.T. Call. He would be joining us very soon, and then we'll call. He's the chair, and the co-chair will be calling Dr. S.C. Srivastav. S.C. Srivastav, sir, please welcome on board. Thank you, sir. Now I'd like to call Dr. Praveen Sinha. He is the president of NLLA, National Labor Law Association. Next, I would like to call Dr. Aparna Sharma. She's Dean, School of Liberal Arts, Noida, International University, Greater Noida. Ma'am, please, we welcome you on board. Can we have a big round of applause for ma'am? Thank you. And among the scholar speakers, I'll start with Dr. Lalit Kumar Sharma. He is Dean and Professor at Mangalmay Institute of Management and Technology, Greater Noida. We welcome you on board, sir. Next, I would like to call Dr. Neelam Tyagi, Associate Professor, Delhi University. Thank you, ma'am. We welcome you on board. Dr. Sunil Kumar Agarwal. Now, I would like to call DG sir, respected DG sir. Right, sir. So next, I would like to call Dr. Sunil Kumar Agarwal. He is an AOR, Advocate on Record of Supreme Court of India. He's a member of Indian delegation at UN BRICS. With these dignitaries on board, I would like to hand over the whole session to Dr. S.C. Srivastava to preside over this session, sir. And needless to say, these dignitaries need no introduction. They are pioneers, they are pinnacles of their own niche, their own forte. So with this, we'll be starting the working session, and I hand it over to Professor Dr. S.C. Srivastava, sir.
Good morning to all of you. Good morning. Okay, it's really a pleasure to be with you all this morning. Well, the topic has already been stated here. We have in India about 44 central labor legislation, and it is the highest number of labor legislation in the world. Recently, we have tried to bring them together with the 4 labor codes. And therefore, we find that even those codes have just on the paper, even though it has been passed by the parliament, but since it has not come into effect, we have to wait. We do not know when it will come into force. But since then, a number of amendments have taken place in the law, which has affected particularly those who are in the lower cadre. Namely, we have the unorganized workers. We are most concerned about the unorganized workers because, as I said yesterday, 92% of the total labor force, they are in the unorganized sector. And therefore, most of the law which is there, it is not applicable to 92% of the labor force. You can very well imagine the fate of the labor laws. I'm more concerned about the occupational health, safety, and welfare. Because I personally feel, as I said yesterday, that this is the basic one. And if an industry or establishment cannot provide even the minimum standards of occupational safety and health. It has no right to exist. As what has happened with the industries about the minimum wage, what we said yesterday, the Supreme Court said that the industry which cannot afford to pay even the bare minimum wage has no right to exist. And I think in this background, we are looking to this. The employer is adopting a different method, adopting contract labor. Actually, those contract labor are directly working under the principal employer. But in order to escape from the liability, they call them the contract labor. And thereby, they deny most of the benefits which are available to the regular workers. They are doing the same job which the regular workers are getting, but they are deprived of many facilities, many benefits which are which are available to regular workers. And this is what is most unfortunate. The COVID-19 has really caused much worry to the daily wages. And most of them, what we could see, that they were deprived of even the basic facilities, even they were deprived of the food and other facilities. The same was the fate of the interstate migrant workers. I think the worst sufferers, the law was there, Interstate Migrant Workmen Act was there, but nobody was aware that there is a law which is in existence. No inspector came who are required to implement the law. And this is the unfortunate situation which you are looking. The impact of COVID-19 is still there. And therefore, we have to re-examine the whole situation, the whole law, not only the law, but its implementation. And therefore, in a number of ways, and there's another thing which is coming up. During COVID-19, the platform-based gig workers came into existence. And this is new phenomena, what we call a digital labor. And we have to find out, even yesterday, Ms. Elena referred to that the ILO is thinking to bring out an international convention on that. But it's all on paper. See, still, I have recently written a paper in the Economic and Political Weekly on the employment status of the platform-based gig workers. I think we have to look after them because they are supplying food at their various places, and still they are denied even the basic thing of the occupational safety and health. So I think these are the issues which need to be addressed. I think in the course of discussion, I will try to develop those things. Now I invite, can you help me? Yeah. Yes. Mr. Dr. Praveen Sinha to please address. कैसे लाइन बता दीजिए मेरे को? जी 1 2 1 2 3 4 so that.
Thank you, Professor Srivastava. Before we hand over the mic to Dr. Praveen Sinha, I just want to say one thing. They are the pioneers of the laws, and they are the encyclopedia of laws. It's always a privilege to hear them. And we, at every stage, no matter what stage we are, we learn a lot from them. So guys, I just suggest you, in fact, to make notes of what they are saying, because they are going to be marvelous in their speakings. Now I'd like to welcome Professor Praveen Sinha. Sir.
Thank you so much. Thank you so much. Good morning to all of you. I'll just put before you few points that basis of which are law, but I will look at the application side, which Dr. Srivastava has already made reference to, the informal sector, the gig worker, the platform worker. And also the impact of COVID and the information technology. that we have come to see that it has acquired the core ground of our action and reaction. And why I want to share with you is that the COVID-19 was a game changer, not only for the business, but also the way we live and the way we interact. And that brought to the core area, the IT sector, which has been there for many years. And India was the pioneer. If you look at the Google, you look at the other companies in US, Seattle is filled with Indians who have been starter and professionalizing the working of IT and its application, whether it is alternative information and other things. I look at the COVID-19 from positive side, how it has impacted the law and also how it impacted the labor per se and the business. To my understanding, COVID brought to limelight the concerns of the labor. Before that, we did have a law and we did have the fighting that is going on in the judiciary between the litigant and the employers. But it used to take, and it still takes, donkey years before a final judgment comes. And you will agree with me that if you look at the workers, they don't have time to wait. I remember in 1988, we started working on the Building and Construction Workers Act. And sometime in 93, 94, we brought together the builders, the trade unions, the lawyers together. But what really happened is that the interests were at play. The interest of the business, the interest of the labor, and of course, the interest of the government. And there you found that what has been legislated in the law, although it looks very well, and also it looks very apt to argue before the judiciary, but in reality, we find that the benefit that should have gone to the affected party does not reach in the right time. It may come later on, but by that time, the litigant is not in a position to enjoy the benefit of what wrong has been done to them. This point came to limelight during the COVID, the migrant worker, the act that came in 1973, Interstate Migrant Act. Almost everybody forgot. The law was perfect. I have had discussion with Mr. Jagannath Mishra, who was the labor minister at that time, and he spearheaded the making of that law. And then his comments were, the laws are perfect, but the problem is the political will. The problem is for you and me to sit together and discuss that where is the meeting point. The second point that really came in limelight is the use of technology. Now, for many years, we have been using typewriter. I was using typewriter, or my colleagues were using typewriter. And I was only, there was clear distinction between those who were officers and those who were subordinate staff. Officer used to dictate, and the junior staff used to take type and all those things. Over the years, what has happened is that there's a merging of function of the subordinate and the so-called seniors. And what it has really impacted is the learning of the concern of the both group. That impacts the outcome of any activity. And that is where I want to share with you that the business is not one-sided affair. And when you really enter into the field, you will find, whether you are in the HR area or whether you're in any other area, you find that you are in the area of application of the law. Laws are there, but laws has to be understood in the context of the society, in the context of business, and like what yesterday the Chancellor said, that it has to be humanized. You see, all of us run family. We are either part of the family or we are managing the family. And the family that works best is the one where is a continuous flow of information between those who control the resources in a way and those who utilize the resources, whether the resources are house or the financial or all other items. And I think that principle needs to come in the business and your working in your psyche also, that when we talk about application of the law, it has to be humanized. It has to be brought in the context of what do you want to draw from that. Mere making law is only starting of the point. When the laws are made by either you look at the legislature, the parliament, or you look at the state assembly, that is the starting point, not an end to it. The application is the one that requires much more attention, and we find that in the last 70 odd years of our existence as an independent nation, there has been a lot of focus on making of the law. Dr. Srivastava already said that we have over 44 central laws, 165, 70 state laws, and about 5,500 judicial Supreme Court pronouncement. Now, this is a jungle. How do you implement these laws? And many of these laws, what happens is that a judgment is made in one specific law. And many a time we find that the judgments are or provisions are contradictory to the provisions of the other law. And that is why when the matter comes to the court, there is always a confusion between litigant and also the two lawyers that we're talking about. How do I see you, and how do I see education as a contributing factor, and how do I see the law and a business management, business administration, and business practices as contributing towards your future and you as a future input to the business and also to the society. Education is seen as an instrument of transforming a Homo sapien, a race, into a thinking person. Education does nothing but it enables you to be critical. It enables you to be questioning, and it enables you to understand the core principle, core of any issue that is brought before you. And I think that is an important in an education aspect, that you not only read the book, you not only take note, but also you examine in the background of your diverse experience that you may have. All of us are filled with experience. We travel in the society, we interact in the society, and we interact with n number of people. And all these are education input that comes into making what we are today or what we will be tomorrow. And that is the major challenge to you, that you not only confine yourself to the reading of the law and the reading of the business, but how you inculcate the principles of law, the principles of business, in seeing that when you interpret a specific provision, you interpret according to the understanding you have about the society, about the environment with which it is functional. This becomes even more important when we look at the globalized environment. We live in a globalized environment since 1991. We have n number of business being run in this country. The lawyers go to other part of the world to fight the case. And the foreign lawyers, I think they have been allowed to come to India to fight the cases. The difference is that when we move from one society to another society, there is a cultural differences, and that conditions one perspective without the application of the law. The law remains same, but what really differs is that the experience that you have acquired, the environment within which you have undertook the learning process, and the environment where you are going to implement the law. So these are some of the, I think, issues that I wanted to put before you. And also, like I said, that education is an important aspect in, uh, in conditioning you to the field that you will be. Welcome, sir. We have Dr. Kaul with us. Welcome, sir. So like I was saying that you are in the process of acquiring knowledge from two angles. And in acquiring angle, you are transforming into from Homo sapien to that of a thinking person, being critical, being compromising, being honest, being sincere to your thinking, and also being sincere to the society at large. And also seeing that you are part of a society, part of the group. You are not alone in this heavily interconnected world. We are in a kind of unity insofar the information is concerned. So we may look different, we may be different, living different places, but somehow we find that internet and IT has brought us so much closer to each other. All of us carry cell phone, and which means that we are 24/7 connected with each other. Whether sleeping, somebody calls you, and you still get up and be information. So be informed, be connected, be learned from each other, not only from who are speaking here and you, but colleagues, because all of you come from different background, and that is a learning process. And I wish you all very good future, and of course very good this yesterday and today's interaction. And I would look forward to listening from the researchers that have come to present their paper. Thank you very much.
Thank you. Law and business, law and education, the application of the law. Hello, yes. Okay. So I think so. May I now invite? Yes. May I now invite Mr. P.P. Paul.
Let's have a big hand for Dr. Kaul. It's a privilege to have you on board, sir.
Thank you so much. Oh my God, I'm so sorry. चलो तो अभी तो आप कहेंगे and here we have I should be leaving around 11:30. Okay, we will talk about it. So I can go ahead and just. Okay, may I now invite Dr. Aparna Sharma to make a presentation.
Oh, very good morning to the august gathering, all the dignitaries on the stage and off the stage. My name is Aparna Sharma, as mentioned by our speaker. When I got an invite from Sir regarding this international conference on comparative labor laws in South Asia, labor and management perspective, I was having an impression that yes, because of my knowledge in and working with law colleges, as well as management degree also, probably I have been invited. I am, if not mistaken, yes, we are full of laws. And not in India, but in other countries also. Definitely because law, it was a mandate since the inception of society. Because we have started with do's and don'ts, and whenever there are certain don'ts, so the people, they need to be checked then and there. Because of that, laws came into existence. And when I talk about management, yes, management also, because we need to deal in so many aspects. Management as a discipline might be appearing new to us, but earlier also, since our ancient times, we were managing things. So that means indirectly management, it was over there. Now, the only thing is that when we talk about in the present context, I mean, with reference to this conference, present labor laws, specifically in South Asian, and as my esteemed previous colleagues, they have also spoken, that various things they changed after the COVID. Now, definitely, I'll also like to add on, but they have already spoken a lot. I just like to say that yes, there are so many people, they need to be accommodated still in that labor category. Because the people, those who are working in online system, those who are facilitating us all those norms, they are also acting in that labor force, and they need to be considered over there. But then there is no as such job security for them, nothing as such norms which are accommodated every time. I mean, the present companies, and I mean, because the specification is not there, so they keep on changing their norms. I'm not saying laws, and then we need to look forward towards laws. So what I feel that with the changing scenario after this COVID pandemic and the boom of this online industry, we need to reframe certain sort of labor laws over there also. Because the person who is working, who are facilitating us on so many aspects through the internet or through the online mode, they also might be facing some problems, and their rights, they are at stake. For that very purpose, we need certain laws to be amended. I mean, this is what I'm just recommending. It's nothing as such which I'm saying. Then what I feel that when we talk about industry and management, amalgamation of management and laws, so I definitely like to say that yes, both of them, they are going hand in hand. We are managing the things, and we are managing the things within the periphery of our needs, demands. And there is the need where we are facing that these are the problematic areas. As per legal perspective, we need to look forward in this direction, X, Y, Z, and ABC. There we feel the need of labor laws where they need to be rectified. Though no doubt that I mean, the industries, they are changing. Our mechanism of dealing with the business aspects, it is also changing. That change, it is still a transit period. We need to work a lot upon the workable, or you can say the satisfactory level of workable conditions in terms of laws and in terms of management. So with this, I just feel, because the Augustus gathering might be having so many papers and so many queries, and every conference, it is actually a step ahead to put forward, to open up certain research questions for the rest of the people and for the students especially, and for the future researchers. So with this note, I just end up my perspective over here. I think that this is a very good effort, and I welcome all of you with very innovative ideas, and I wish for your futuristic development. Thank you.
Thank you. Thank you, Dr. Parag Sharma. May I now invite Dr. Lajit Kumar Sharma to make his presentation.
Yeah, good morning, all the dignitaries on the dais and off the dais, my respected colleagues and my dear students. So, like when we're talking about the perspectives of law, so really very difficult to understand really what is the perspective of the law, because law is applicable to each and every sphere of the life, whether it is a professional life or a personal life. It is operational part or it is a nature, it is society. Law is applicable everywhere. So I have my own thoughts. And first thought which comes to a normal human being, if I talk about myself, I have been suffered a lot because of certain laws. And when we don't have understanding of these laws actually, though it is very easy to say that laws are meant for the people, for the well-being of the society, but really is it developing a well-being of the society? So I've just discussed what all has happened, how I've experienced the laws in the country, in India as well as outside the country, because I've spent some of the time in multiple countries also, where I've experienced that how the law is functioning. So generally we say that law is for the protection. So I just share a small example. I started my career in 98, and my first company which I joined was Cipla Limited. So like it was a pharmaceutical sector. So I spent almost first 12, 13 years in the pharmaceutical sector also. I was a zonal head in which I was covering almost half of the country. So one challenge which I have seen, that when the person is working in Cipla, or later on I was with Ranbaxy. So my executive who is working in the field and meeting to the doctor is in management category. When the person from my competitor brand, who is also doing the same job, he is also meeting to the same doctor, he is also performing the same responsibility which is performed by my executive, is working as medical representative. And my person is getting the designation of marketing executive. Now the flaw comes, for the same nature of job, we have two different laws. The person who is doing the job in my company, the same job, meeting to the doctor, promoting the brand and getting the prescription, is in management cadre. So he's not eligible for the benefits of the labor. Now the person who is working in other companies, who is also doing the same job, meeting to the doctor, doing the promoting the brand, getting the business, achieving the target, he is having the by virtue designation of medical representative, and their company is having the union. So he's getting all the benefits which are meant for the laborers. Really, is it not something very disastrous, I will say, in the corporate if I talk about? So probably someone has made the law, but have they understood what is the nature of the law in terms of implementation? Like Srivastava sir was talking already in the beginning, probably implementation part in the law is biggest challenge everywhere. And probably that is a big challenge to the countries like India. 1984, first of all, getting the judgment. 1984, Bhopal gas incidents, we all know about that. What happened that probably in 2017 or 18, we get the judgment after 34 years. Just see how many people were really present in this world to get that judgment. And when the judgment has come after 34 years, only 20,000 rupees was the compensation which was to be given to one single family. And the same would have happened in America. Compensation amount was $1 million. If I talk about Indian currency value, that time also, it was coming somewhere around 68, 70 lakhs of rupees. That is the value of the human being. So probably what I feel that we need to understand that when we are really making the law, actually law is for whom? That is the first thing. Second thing I talk about as a society when we talk about. In 2009, I had an accident. It was in Noida itself, near to this MIT University. So what happened on 19th of September when a tractor was coming with full speed, and there was 2 lanes, no divider. So the lane in which I was there, so huge traffic jam. My car speed was hardly 10 kilometers per hour, I will say that. So you can know my car was almost in the ideal position, it was not moving. So a truck driver is coming because that road was absolutely open. So a tractor driver was coming. I was thinking, man, I don't know what he will do today. Definitely he will kill someone. And then he has come because of there was a concrete on the road. Then he has applied the brake. Immediately his trailer has been fallen down on my car. Only God was great. I escaped. Now the tractor driver is there. I still had almost 30 stitches in my hand. My right elbow was broken. I had lots of internal injury into that. Now entire drama goes on for 2 hours. After 2 hours, even after giving the call, and sector 39 was, if I'm not wrong, it was hardly 20-25 minutes away from my place. So then police has come, because just see who are the caretaker of the law in this country, police and lawyers. Now the police is there. The person who is culprit, he is there. That vehicle who has hit me, that is also present there. Do we require any kind of law proceedings in this really for so many days to happen? Is it not like an open and shut case? But it is not open shut case. It is a never ending case actually. So I had lots of injury. I was hospitalized. So 19th was in hospital. I've gone to first of police station. So just inform the incidents. Then police officer said, okay, you just go to the hospital and get all the treatment and all. So we can meet tomorrow. Now tomorrow, so that entire night, that person, his driver name was Sonu. He was from some nearby village. So he was behind the bars. Now next day morning, my father and me, only 2 people are there. Now there's a lot of somewhere around a crowd of around, if I'm not wrong, 70-80 villagers. That police officer. So he just tried to sort it out the things, but somehow things were not sorted out. So we lost FIR. Still, I have that FIR copy. My father has paid 500 rupees to a police officer also. Name was R.K. Rastogi. It was 20th September 2009. Today it is 29th August 2023. Almost 14 years are over. I have never been called by that police station, Sector 39, neither by any other officer or nor by Mr. Rastogi. Do we have transparency in the law? Of course not. So really when I'm talking about the law, actually law is for what? Safeguarding whom? So like sir has told that we are part of the globalization since 1991 onwards. When we were having the communist kind of economy, when we were highly oriented towards the labor. So money was not priority. Protection was the priority. Karl Marx has said, every government job is to feed its people, first of all, even without productivity. But can we be part of the globalization without productivity? My question to all the students, can we be part of the globalization without becoming productive? Yes or no? And now these are the laws which are probably very much influenced by the British culture. And now I'm talking in the 21st century, when we are talking about productivity and all. Do you think still these laws are really valid? One side we are talking about the protection, but you just see that running the business in market in a global world, is it so easy? So one side when I'm talking, so when we talk about factor of production, land, labor, capital, and entrepreneur. So the moment I'm trying to safeguard the interest of my labor, I need to ensure that I'm not going against to the interest of that investor also. Because the person who is taking the entire risk in doing the business, in running the entire function of the economy, if his or her interest is not protected, then really why he or she, that management, that owner will be interested for the development and for the globalization. And if we don't have the economic possibilities in the country, can we really give the job? Just see how much time it took for us to become a $1 trillion economy, and how much time it took for us to become a $3 trillion economy, and how much time it is going to take for a 5 trillion economy. So probably those laws which we are having, what I feel need to be relaxed, need to be re-evaluated, so we don't have discrepancies over the implementation part. So like I've given the example, then the transparency part need to be there, so that we can check, like just when we go for the passport application, it is very transparent process now. Online you can check, but can I see the progress of my case online? Recently I have seen Amar Mani Tripathi was behind the bars almost for 17 years, some months he was into jail. Now he has been released. Now next case is going to open. So the case which has taken place almost 17 years before, why nothing was done in last 17 years? Who was waiting? Why we were waiting for that much time period? It means lots of influential factors are also working, which are stopping the law to work as it should work actually. And one last point comes, like law is meant for we people, especially not to those who know the law, especially to those who don't know the law. But are we able to get the benefits of the law? So like so many students are there, you're going on the bike, red light crossed. How much penalty to be paid? Do we know? We don't know. So maybe you need to pay, let's say 1,000 rupees, but you don't know about that. So what do? You just give 500 rupees to the policeman. If you know that the penalty is only 1,000 rupees and this policeman is charging 500 rupees from my pocket, what will you prefer? Would you like to pay 500 or would you like to pay 1,000 rupees so that it should go to the pocket of the government or our economy? And my countrymen should get the benefit of the same? Or you would like to give 500 rupees to the policeman? Anyone can answer? So I asked to a boy, yes, फाइन हो गया, चालान हो गया, 1,000 रुपए देना पड़ेगा. दो ऑप्शन है, 500 रुपए पुलिस वाले को दे दो या 1,000 रुपए गवर्नमेंट के अकाउंट में जमा कर दो. गवर्नमेंट के लिए. I was in Singapore. I tell you because this psychology works. Because understand, like I did my PhD working for last 25 years, but I have never been groomed as per the law requirement. क्योंकि law का डर ही नहीं है हमें कहीं भी, क्योंकि समझ नहीं है. I just talked about the example in the Singapore. When first time I went to Singapore, I was there for the 3 months assignment. So I got to know chewing gum is banned in Singapore. और बहुत सारे लोग जो फ्लाइट में जाते हैं while traveling, they want a chewing gum so that they keep on chewing that, so that their ears are not closed. Now, many Indians, luckily I'm not fond of chewing that, but many of the Indians were having a pocket full with their chewing gums. Now on airport, announcement was made, these have to be dumped or thrown into dustbin. Because there is a heavy penalty if you are chewing on road and you spit on road. Even spitting is not allowed on the road, and entire Singapore is under surveillance. You just try to have a crime, think of having the crime and just do it. It is my guarantee within 24 hours, you are behind the bars. Because I've experienced the same with some of the people there. So now another thing is that developing the character amongst the individuals to abide by the law, to follow the law in society. Normally what happens when today a law has been developed, what thought comes to the people? तोड़ने के 1000 तरीके देख लेंगे. Is that the respect we are having for our judiciary, for the law in the country? So what I want that really, first of all, if we really want to work out on the laws and all, we need to change the image of our judiciary system. We need to ensure the efficient implementation of the laws, and which is working in favor of the people there. Because till the time people for whom the laws are meant for, if they are not going to be benefited, no law, we may have thousands of the laws, but it is not going to help anyone in the country. Because that respect is not there. Then who is respecting? We may talk about Adani and all, but ultimately, whatever the Adani has done, who is permitting him? Whatever we all know, we have all seen the movie Guru. Whatever the Dhirubhai Ambani has done, he has admitted that. Is that not the failure of the law? So probably every law is good. I'm not denying from that. Whatever the laws are there, obviously that is meant for some purpose. But till the time we don't have the right force in implementing those laws into society, into corporate, into the nature, into the society, no benefit will be occurred to anyone. So when we are talking about the law, we should abide by the law. I do 100% recommend it to everyone, but we need to ensure proper understanding of that. And here the role comes for these kind of law institution, that they need to have lots of awareness programs in the society where they are just upgrading the knowledge of the people about the law, so that people start knowing about the law. Because under all the law students who are there, I'm not talking about them, but all the people and the faculties who are not part of the law, really, are they aware about the law? Are they aware about the kind of benefits available to them in the system? Kind of laws available to them? They don't know. So with this, I will conclude. Thank you.
Well, Dr. Sharma has raised a number of issues. The first issue is most of the law has become obsolete. Employees Compensation Act was passed as early as 1923. 100 years have elapsed. Even some amendments have taken place, but I think there is a need to relook the entire law. There is a procedural issues. There are delay in disposal of cases. Even the inspectors who file the complaint, most of the time it is not accepted by the judicial members, and therefore the case is dismissed. We have problems of arising out of and in the course of employment. Unless an accident is arising out of and in the course of employment, one is not going to get compensation. And then the last point is about the amount of compensation, whether it needs to be reviewed. I think these are the issues which still require consideration. May I now invite Dr. Neelam Jati, the Associate Professor in the University of Delhi, to make a
Yes, all of you. So a very good morning to one and all present here. So this is a small and a very brief kind of a presentation that I'm going to give to the students, especially to the students, because for them only this program is organized. And I think it's a great idea to organize such devoted conferences, because, these conferences provide you a platform where you get to hear so many ideas on a particular field. So the presentation is divided into 5 parts. First, I'll briefly tell you about some statistics. Secondly, I will discuss 11 issues which are persistent issues, especially in the context of labor laws. Thirdly, I'll be giving you some recommendation based on my understanding of labor laws. And lastly, I will discuss that what can be done in South Asia specifically, because the conference is all about the situation in South Asia. So what can be done in that situation, regarding this, that is going to be my focus area. So, if you look at the meaning of the term labor, there is a very fancy definition given to it. It says employment in the economy of India. So it seems, as if labor is everything and, they are doing everything for the economy. But when you look at the ground realities, things are absolutely different. If we consider the statistics which are given by Labor Bureau, and again, sir will kind of confirm to my statement that even the statistics that are proposed are not properly calculated. There are flaws in the way these statistics are calculated. So majority of the labor, like 94%, as per the data of 2022, some 523 million laborers are there in India, but majority of them, say around 95%, are confined to the unorganized sector, and 45% are confined to the agriculture sector, which is regarded as non-contributing to the GDP of India. So this is the scenario with which we start. You must be by now aware of the various laws which are prevalent, the international convention, the role of ILO, etc. The Labor Commission, etc. What are their roles, etc. I mean, I'm not going to the nitty-gritties of it because Kaulsar is around, and let's hear from him. This is the situation. Also, there is a lot of overlap between the state. I hope all of you are aware that there are 3 lists in the constitution, and the labor laws, they fall in the concurrent list, which means that the state and the union both can make laws on this particular aspect. And that is the reason why there is a overlap. And as sir pointed out, there are some 44 laws, some thousands and thousands of state laws, etc. So if there is so many variation in laws, I mean, conformity and uniformity is going to be a problem. So there are these laws which are proposing the 4 codes which are proposed in 2020. Sadly, it's been almost 3 years, but they are still pending, and I don't think so. In the near future, also we will see these uniform kind of code, or I'll say the code which are consolidated, which are simplified for the laborers to understand. Of course, there are so many authorities. There's overlap. People don't know where to go. The dispute resolution mechanism is also a challenge, in the sense that we are not utilizing the alternative dispute resolution mechanisms. We have the concept of mediation and conciliation, but then how far they are utilized, I mean, this is again a question that we need to ponder about. Also, there are problems like contractual labors. There are zones which are made where the applicability of labor laws is a problem. Then we have these contemporary issues of gig workers. There is this phenomena of kafalal that I read, wherein you can go to Saudi Arabia and they will pose their own terms and conditions for work. And it's again a challenge for the laborers to survive in those kind of situations where they are constantly under a fear of losing their job. So I mean, I can go on and on about the challenges, but my point is that, especially in the context of these new areas like people with disability, the women, the children, the transgenders. These are the areas, and the stakeholders for whom, we should be doing a lot, especially in the contemporary times. Coming to the solution that I want to propose, I'll say that, of course, the consolidation and simplification of the laws it should be a priority. The dispute resolution mechanism should be fast-tracked. India should sign the ILO convention, which they have ratified, or they have made certain reservations about it. They should be ratified in full spirit. For youth, the employment exchange can do a lot. They can kind of bridge they can act like a bridge between the youth which is unemployed, and there should be more collaboration so that new opportunities are brought to these youth who are sort of not employed. Coming to South Asia, I think there should be more and more collaboration. We should learn from each other, in the sense that whatever is the best practice followed in my country, that can be shared with the other countries, and this is how we can grow together. So I think that's all. I mean, there's a lot to say, but I would like to wind up my talk, because my teacher from Campus Law Center is here. I mean, let's hear from my teacher. Okay, thank you so much.
Thank you, Dr. Neelam Tyagi. See, she has made 2 issues. One thing, labor is the human capital. The first thing, once we have the system of the law, I think the first thing we must understand, that which the employer is not able to understand, is that labor is also human capital. But unfortunately, our laws Even to denote the workers, we have used three terminologies. Worker, which is defined under a different act. We have the employee, which is defined, and then we have workmen. Even to denote the word workmen, we have three terminologies in three different acts. So you talked about the concurrent list. I would like to draw your attention that not only in India, but also in Pakistan and even in Indonesia and other countries also, they have placed labor in the concurrent list. Even Sri Lanka also. Then we talked about the mediation and conciliation. Under the Industrial Dispute Act, we have only conciliation. Mediation has not yet been incorporated so far as the industrial dispute is concerned. You talked about the transgender. Under Minimum Wages Act, we have tried to improve that one. So we are going to take into account, and even the new code has taken that into account. So as ratification is concerned, once India ratifies the law, it is bound by laws to ratify, to provide it under law. That is why yesterday we were talking about the right to form associations and unions. India has not ratified because it knows that if we do this thing, we have to provide the same thing to the people. So these are the issues which need to be addressed. Thank you so much. May I now invite Dr. Sunil. You think that? Yes.
Good morning to all. At the outset, let me confess that labor law is highly complex in the sense because it impacts a large population. Presently, around 50 crores have been categorized as the labor in India by the government of India. So you can understand the implication and the ramification of the labor laws in India. Coming to the labor laws, the one dimension, labor law is just not limited to the national issues because there is an international dimension, as Professor Srivastava and others also have described about, especially the ILO obligations. I'd like to draw attention to your this international dimension, how the India implements the labor conventions that it has ratified, and why India has not ratified conventions like freedom of association. There must be some reasons for that. So coming to the international dimension of the labor laws, let me tell you there are, India has ratified almost 41 labor conventions, one protocol, presently out of existing 155 international conventions and other recommendations. As we know, there's a kind of a linkage between the international law as well as the national laws. That is through the system. Every country has their own system of implementing international convention that it has ratified or had agreed to enter into force. In the Indian Constitution, we follow the dualistic approach. The India, unlike the countries like US, etc., do not have the system wherein the international convention is directly enforceable without having a corresponding legislation in place. So we follow the dualistic kind of a form of ratification process, wherein even if India has ratified a convention, it may not be enforceable unless and until the Parliament in India makes a specific legislation pertaining to that issue only. So I think that give you an idea about how the international conventions are adopted and implemented in India, because this is very important to understand the international dimension, because everyone has got this idea that why India has got certain international obligations and it is not enforcing or implementing. And there are many cases, especially the cases on the freedom of associations in the Supreme Court also. There are many, especially because as we know, the labor issues are not the it's not the regulated just by the government. It is the tripartite system which is in place. Means basically it is the representative of the employer, the representative of the labor unions, as well as the governments, which decides on the labor standards. Definitely the labor standards are aimed at bringing out or bringing in place a unified working condition for the laborers at work. However, as we know, the national conditions are definitely have to different at various levels. Those things have to be considered in analyzing as far the enforcement, the implementation or application part is concerned. In fact, coming to the association convention, the main reason, as we all know, the reason India has not ratified this convention is primarily because it ratifies, it will violate certain domestic regulations or legislations, especially pertaining to government servants, because government servants have been under special, they are regulated by their own laws. I think the civil services laws are applicable on them, which which do not permit them to get into the have this right to freedom of association. That is the primary reason the Indian government has till date has not and still because of the complaint procedure under the ILO, there are many representations are being made from time to time against the government of India, uprising that certain laws, especially recently the Essential Defense Services Act was in issue because it was in relation to the violation of the Freedom of Association Convention. But since India is not a neither the signatory nor the ratifying country, so it is not. It is presently there is no international obligation as far as the freedom of association is concerned, and definitely it is engaged with the ILO as well as the labor union to find a better way out on this issue, and it will happen. But as far as presently till date, there is no international obligation as such. All right. So coming to the another issue of, let me give you the idea about how this ILO functions, particularly the labor standards, how they influence the national lawmaking. In fact, as we all know that international labor standards are basically developed by the ILO. ILO is the primary specialized labor organization of the United Nations, where we have the representative of the government of India, of all the member states representing the government, as well as because there's a tripartite sort of system, there the respective labor unions as well as the employers representative would be there. So it is India is a part of this ILO system since very beginning as a founder country. And presently, as we know, there are the labor standards have been establishes basically the basic principles and the rights at workplace with the aim of improving the working condition on a global scale. That is the primary aim. And the reason we do it is only the objective. The reason we are not able to have the common standards everywhere, the idea is to have the certain minimum standards enforced across globe. That is the idea. How it is done at the national level, this is still an issue because of the different conditions prevailing in different countries. India is still a developing country. It is not a developed country like United States or the UK, etc. So definitely we have to take a nuanced approach rather than have a kind of overwhelming similar sort of approach. These standards are backed by the supervisory systems to address their application at the national level. This is how it happens through the reporting system, because there is a reporting mechanism also, national level. The government every year, they have to submit the report to the various committees set up under the ILO, as well as there is a kind of a system of representation and the complaints. This is wherein most of the times it happens that countries are accused of not implementing certain conventions. But as for the coming back to the national level, I would say that in the recent time, in the government of India is doing a lot of good work, in the sense that Shramik Suvidha portal is now in place, wherein the old problem of inspection reports, etc., the documentation that the companies need to submit, etc., have been resolved to large extent, has been resolved, it has been eased out. And not only that, most of the things have been digitized now to help not only the employer as well, but to help the labor also to get the best kind of response system, etc. So I would say that coming back to, let me conclude by saying that coming to this labor laws, etc., we have to keep in mind that there is it is a multi-dimensional issue. Definitely, the national laws are there, but these are to be integrated with the international laws. But that can only happen. We cannot have a similar structure, similar system everywhere, because of the fact that national conditions, the domestic conditions, the prevailing conditions, etc., and the stage of development differs from country to country. And similarly is the kind of case with the India. That is why you would have a lot of issues with regard to implementation of the International Labour Convention in India. In fact, this is an issue which is very important as a student for you. It is an issue for research. There are various issues which the student can take up, and for their dissertation, for their whatever purpose, writing paper, articles, etc., it will be, I would urge them, from their perspective, it is a very important issue. And as far as the other professionals are concerned, definitely these are many issues are under discussion. The government also is keen to resolve many of the unresolved or kind of all these problems as far the labor domain is concerned. I think I conclude my whatever perspective that I wanted to share with you. And I would be happy if some kind of questions and answers are there. Thank you.
Thank you so much, sir. Please.
There is number of issues. I will just to react to two issues. One is whether to ratify or not. The core convention has to be adopted. One thing which we must know. And secondly, in the making of the labor standards, we have all three organizations. We have the employers representative, we have the employees representative, and we have the government. So all the interests are taken into account. Thank you so much. Yes, please.
Thank you, sir. We, as a law student, we never stop learning. We have students, we have a large amount of students who have already studied law, who are studying law, and who will be studying law. And during this journey of learning and learning law or studying law, we kind of develop a liking for certain professors, right? So I'm sure everybody would have their own favorite professors. But today we have the privilege of having Professor B.T. Kaul with us, who has been an inspiration to the students who have done law, who are doing law, and who will be doing law. So I just want to have a very big hands together. Well, let's put our hands together for Professor B.T. Kaul, who is currently who is currently the professor in charge of the Faculty of Law at Delhi University. With 34-year teaching experience, intensive career, he specializes in criminal law, labor law, intellectual property laws, and interpretation of statutes. He has a LLB and LLM from Delhi University, LLM from London School of Economics, and PhD from Delhi University. He received UGC Research Fellowship for 6 months in 2007 and is involved with the Indian Law Institute and Indian Society of International Law. And trust me, I can go on and on and on praising Professor B.T. Kaul. So I wholeheartedly, on behalf of Maharishi University, altogether welcome Professor B.T. Kaul. Sir, it's a privilege to have you here. And before that, I would like to call our respected DG sir to felicitate Professor B.T. Kaul. Sir, let's have a big hand for both these dignitaries. Thank you, DG sir. Thank you so much. And now I would like to invite Professor B.T. Kaul, sir, to address the chair.
Professor Group Captain O.P. Sharma, Professor K.B. Asthana, Dean, Law School, Maharishi Dayanand University, our great teacher, Professor Srivastava, who has been our mentor, in fact, my mentor also, Professor Dr. Praveen Sinha, President NLA, Professor Aparna Sharma, Dean Law, National University, International University, is it? Noida. I'm sorry I was a bit late, got stuck on the way and could not reach in time and suffered a little accident in my car in the hurry that I was in. Labor law has been a passion for me. In fact, one of the subjects which I have enjoyed teaching all along. I have left teaching now, so I do not know how much of my memories still are with me, but I still would like to deal with some of the issues that are very contemporary issues. In fact, if we have to see the problem of labor law, problem of the labor, we have to recall the plight of the laborers during COVID-19. The plight of the workers in COVID period and thereafter show how fragile the edifice of the labor law in this country is. It also shows how inadequate the medical infrastructure we have in this country. Therefore, seminars like this are very important for relooking at the policies relating to labor welfare, social security, and public health system. The situation became graver because it was during this period only that many state governments, on the pretext of revival of economy, issued ordinances sending to winds whatever little rights that labor had by extending the working hours from 8 hours to 12 hours and annulling their right to overtime wages. Such a move on the part of the state government of Gujarat and other states were to follow it was struck down by the Supreme Court in a well-celebrated judgment of Gujarat Mazdoor Sabha versus State of Gujarat. I was not very sure what will be the outcome of this petition because Supreme Court had not portrayed itself in the manner it should have while dealing with the problems of the migrant labor. Those of you who are serious students of labor law will appreciate that all the important legislations relating to regulation of labor management relations in this country are pre-independence legislations. We have the Trade Unions Act of 1926. We have the Industrial Disputes Act of 1947. We have the Industrial Employment Orders Act, Standing Orders Act of 1946. All three legislations which regulate industrial relations in this country at the central level are pre-independence legislations. But the flesh and blood to this law was filled by the judiciary of this country. And this position is a very beautiful study for any student of labor law. You start with Federal Court's judgment when it said that labor court has the power to rewrite the contract of employment. And it has the power to order reinstatement, back wages, continuity of service. This was the foundation of the labor jurisprudence in this country laid down by the Federal Court of India. I think it was in All India. Bharat Bank was earlier, that was Supreme Court, but it was I'm not recalling the name of the case, but it was Justice Mahajan in Federal Court. And as soon as we got the Constitution of India, we had the Bharat Bank's case. And Bharat Bank's case was a monumental judgment because Supreme Court said in Article 136, word tribunal includes quasi-judicial bodies. And that gave the power to the Supreme Court to deal with the lowest court to the highest court. The awards of the labor courts came to be challenged in the Supreme Court directly. And it gave the opportunity to the Supreme Court to lay down a uniform law in the country and lay down the foundations of the labor jurisprudence in this country. But when you see those judgments in the post-globalization period, you find the Supreme Court going down. And it was only in Gujarat Mazdoor Sabha case that we got some life again into this law. And the Supreme Court, while dealing with this case, talked about a very wonderful amalgam of the rights of the workers. It said, the right to life guaranteed to every person under Article 21, which includes a worker, would be devoid of any equal opportunity at social and economic freedom in the absence of just and human conditions of work. A worker's right to life cannot be deemed contingent on the mercy of their employers or the state. That's talking about the rights, fundamental rights of the workers. The notifications in denying humane working conditions and overtime wages, that is what was the ordinance trying to do by issuing a notification under Section 5 of the Factories Act, relaxing the provisions of the Factories Act so that workers could be subjected to inhumane conditions of work and denied their overtime. are an affront to the workers' right to life and right against forced labor that are secured by Article 21 and 23 of the Constitution of India. Now, this is very important for the students to understand what the Supreme Court has to say with respect to the human rights jurisprudence in this country. The court is cognizant that the respondent aimed to ameliorate the financial exigencies that were caused due to the pandemic and subsequent lockdown. However, now this is where the harmonization of the rights of the workers and the industry, and where there is a conflict, it is the right of the worker which must gain the supremacy. However, financial losses cannot be offset on the very shoulders of the laboring workers who provide the backbone of the economy. Now, this is something very, very important that we must understand. And this thinking of the Supreme Court is consistent with the thinking of the ILO. And when ILO was confronted with the situation of globalization and liberalization, it came out as a bulwark to protect the rights of the workers who were affected by the new economic order because of the globalization. To mitigate the effect of globalization and liberalization, ILO adopted the Declaration of the Fundamental Rights of the Work 1998 and the Decent Work Program 1999. The former committed all ILO members to respect principles and rights in 4 areas. Now, I'm not going to the many areas, I just confined to 4 areas. And that is what Professor Srivastava was talking about, why India is not ratifying. And he was giving the reasons why India is not ratifying this convention. Freedom of association and collective bargaining. Forced labor. And Gujarat case talked about the forced labor when you make a person to work from 8 to 12 hours. Child labor, another important area that you need to look at, and discrimination at work. All forms of discrimination must go. The concept of decent work encompasses recognizing work as part of the core identity of the human beings, giving working lives meaning and dignity while allowing us to support ourselves and our families. Decent work becomes the root of social cohesion and the catalyst for poverty reduction in all societies. Therefore, need for countries like India and South Asia, who are developing countries, to begin anchoring its development strategy in decent work framework. But unfortunately, the situation at the ground is, the fact of the matter is that it is only 9.11%, but I think you are quoting statistics of 2020, maybe I stand corrected to that extent that it has even gone down. Of the labor which is organized, whose employment conditions of service are regulated by labor law. And Indian labor law by far has been in consonance with international labor standards. However, I think somebody else also talked about it. I think Professor Sharma talked about it. In the working of even such laws, we are having issues in their operationalization, implementation, and therefore the machinery needs to be geared up and sensitized. Although we have the laws on Equal Remuneration Act 1976 and Maternity Benefit Act 1971, which has been amended, we have seen even employers that are supposed to be model employers have been found wanting by the apex court in operationalizing and implementing these laws. Reference can be made to the Supreme Court judgments in Salal Hydro projects. That was the first case on migrant workers. And that was the case where court talked about the rights of the migrant workers and highlighted the pitfalls and how to provide remedy to those pitfalls. People's Union of Democratic Rights Assured Workers case. Municipal Corporation of Delhi versus female muster roll workers. Right of the workers to motherhood. Female workers to motherhood and therefore maternity benefit. Vishaka versus state of Rajasthan. In order to create free and fair environment for women workers at workplace by laying down guidelines regarding sexual harassment, which ultimately have been given the statutory form in the POSH Act of 2013. However, we still have a long way to go in enduring a free and conducive atmosphere for women workers to enjoy their right to earn their livelihood, which will require sensitizing their counterparts in workplaces and in society at large. COVID-19 has transformed the whole world and has demonstrated that importance of technology, which has gained great importance as the flexibility relating to carrying on business of employers is also equally now gaining importance from perspective of the employees who are also seeking flexibility in employment and conditions of service. However, there is a distinction between flexibility in the matter of choice and the flexibility as a compulsion. For example, we have Zomato, Uber, Ola. Therefore, there is a need to regulate and ensure that they get fair deal and decent work. The importance of the judgment of the Supreme Court of England in UK in Uber BV versus Aslam, it's a case of 2021, becomes relevant higher as to how the Supreme Court upheld the decision of the Industrial Tribunal and Court of Appeal to hold that Uber driver is a worker for the purposes of employment legislation that gives workers rights and other employment benefits. Now we have to examine all the four courts which are going to be subsuming various legislations, plethora of legislations, in the light of these values, and to see whether they need not to be relooked at, keeping in view the COVID-19 situation. We have also to see the judges are sensitized to deal with the issues not as the law of contract, but it is a case of status of the workers, and the rights of the workers must be protected at all costs. Thank you very much.
Thank you, Professor Kaul, for an excellent exposition and presentation. But I think he has raised a number of issues. And I think I will start just saying about the Gujarat Mazdoor Sabha versus state of Gujarat. According to me, the case has made a significant contribution to the industrial institutions. But it has not only made significant contribution, but it has presented a clear vision of social and economic democracy. Particularly when they talked about the principles of paying the overtime. The central said that there's a double rate is a bulwark against the severe inequity that may otherwise pervade the relationship between the workers and the management, and workers cannot be contract out of reviving the rate of wages. I think that is the principle that you cannot contract it out by just saying this thing. So this is the first issue which needs, I think very well, I'm just making some footnotes to that. Then the second issue is about child labor. And my view, as I've written in the book, a child who doesn't go to school is a child labor. And if this principle is adopted, perhaps we can meet number of, whatever the reason may be. If a child doesn't go to the school, he's a child labor. That is the theory which I have tried to propound in my various books. Well, then, I would like to invite one of the recent judgment, the Anganwadi workers. And I think I must say it is a great contribution of Supreme Court where they have considered Anganwadi workers to be workers and they are entitled to gratuity, irrespective of whether their appointment is for a certain period, whether the payment is made in lump sum, whatever may be the reason. I think it is a landmark judgment. Yes, which has been reported in year 2022. Well, maternity benefit also, the number of decisions which Professor Kaul has mentioned, that even for the contract job also, even if it is worth 1 year, the maternity benefit would be available. Even the contract labor would be entitled for the maternity benefit. I think these are the issues which need to, there are one issue which is, I think, which has come in under the labor code, and that is compounding of offenses. I think that is the area which particularly requires review. I think these are the few points which I want. See, I think I'll be here for the whole day, and I think I've just made some of the footnotes to the points which have been made for the learned speakers. I'm extremely grateful to all the learned speakers who have made number of issues, and I've learned a lot from them, and still I'm in the learning process. I hope that our students will be benefited by the expositions and by the presentations made by the learned speakers. Thank you so much for providing me this opportunity to share some thoughts with you.
Thank you, Professor Srivastava. I am Vikas Sharma, Assistant Professor, Maharishi Law School. This is my designation. But before that, I am a learner, I'm a student. And I'm standing beside 7 encyclopedias. And I've been diving in this ocean of knowledge for the last 1.5 hours. And we all have, experienced a lot. We have gained a lot through the speeches made by these dignitaries. But one thing is for sure, that we need an inspiration. We need a source of inspiration. We need an inspiration to study, to do anything we want. And for past 3 years, for me, the source of inspiration always have been DG sir. So I would like to request DG sir to come on board and make this a lethal combination of knowledge and the inspiration. Please, sir. Thank you so much. Please.
Vikas has been all the time a learner, and more so under my direct supervision. He has been doing wonderfully very well. And let me first congratulate him for convening, conducting, executing the task which was given to him for this working session. Well done, Vikas.
Thank you. All
We started off late. Generally, teachers, they insist the students to come in time, but they get late. So it doesn't matter. We are all teachers. The issues which have come and so very well dealt in a scholarly manner by Professor Srivastava, I must place on record my deepest appreciation for him. So well, wonderfully done. The question that arises before us is, all this is a matter of education. यूं तो सब कुछ बदल रहा है जमाने में, यूं तो सब कुछ बदल रहा है जमाने में, पर आदमी इंसान नहीं बनता. And there is the crisis. You take labor law, you take perspective of management, you take perspective of labor. You find आदमी and आदमी. There is no insan. And what makes insan out of admi? Is education. We both this side and that side are primarily involved in the area of education, which is the area of learning. And please remember, human to be humane. Human to be humane. And this E in the end, which I have added to human, to make it human, is education. And education, as I have conceived, and what we practice in the university system here, and wherever during last 6 decades of my educational career, I have been associated with many organizations. And still, I am associated now with 280 organizations in the field of education. The education is the process to ultimately achieve 4 important characteristics in all those who are the target of education. And that is D, P, M, and T. Incidentally, for easy learning, I call it Delhi pre-medical test. D, P, M, T. All else, all issues, whatever we have talked yesterday, and so brilliantly attended by all the scholars sitting here on the dais, could be solved, could be sorted out, could be resolved through DPMT. And that is education. D for discipline. Doing things and doing right things in right time, in right situation, with reference to the right social system, with reference to the right people. And what is right? Right is, which is right for me, right for them, right for you, and also right for those who are not within the range of your hearing or within the range of your seeing. That is the concept of righteousness. That is right. Second is P. P for proficiency. Law, labor law, but so must make our labor proficient. And proficiency will include individual management, personal management, organizational management. What are these? Personal management, O.P. Sharma to O.P. Sharma. And all the people though who are involved, they are part of my personality, my management with them, my management for them, my dealing with them. Organizational, we all know. Incidentally, family is an organization. And then move upwards, take the social system, take the organization, say university, take the social system, take the society, take the country, take the entire world in the context of Vasudhaiv Kutumbakam. We got to consider this part. And that is the part of proficiency, effective role play. In all dimensions, not only in one dimension. DPM. M is moral. MORALE. Don't mix up. My dear friends, this side, moral to be moral. Moral is different. Moral is different. I'm talking of moral, MORALE, which means, in general common sense, a sense of belongingness. I belong to the labor, and labor belongs to me. Labor belongs to law, and law belongs to labor. Go further, law belongs to legislatures, framers, as much as law belongs to the labor, as long as it becomes a part of the management process. So everybody included is inclusive in this MORALE. All are inclusive. Yesterday I talked at length about control and inclusiveness. This morale is a factor which promotes inclusiveness. And last word is T. And T, what we have been talking, and I have been insisting all the time, I keep insisting whenever I am at the podium. T for togetherness. T for teamwork. We have been very fond of, particularly in South Asian countries, we are developing countries. It is the colonial heritage which we have got. We have been all the time working in isolation and trying to derive satisfaction as an individual. And the all difficulty that you find there in implementation is because of this factor that we have not thought of making the law either in the spirit of togetherness or the implementation by the executive agency in the spirit of togetherness, or for that matter, those organizations which are dealing with the default, again, not in the spirit of togetherness. We work in isolation, and that is the crisis which we are confronting today. My dear friends, particularly students and the faculty, they must utilize this opportunity which they have got today. Let me share with all the scholars, because this is the new innovation which we have introduced in the university. After every conference, the scholars will be invited to have a working session in this manner, so that we really convert the conference not only a matter of dialogue amongst those who are sitting on the other side just to listen, but also for our students and faculty, a learning moment every time and any time. With this, I'll conclude with my sense of gratification and a sense of gratitude as well. I left in between while Professor Cole was there to attend the urgent call. And the urgent call was from the Chancellor. What he said, DG sir, जितने लोग आए किसी को जाने मत देना. Because our philosophy of the university is that there is no exit gate. Once you have entered, well, you have entered. All exit gates are closed. That is what he reminded me through this urgent call when I went outside to attend the call. And I did not miss anything because the voice was still crossing the frontiers of the wall of this hall. This is all which I have to say, and bless and give my greetings to everyone sitting here. Thank you. God bless.
Thank you so much, DG sir, for these words of appreciation and source of inspiration. With this, I would like to call Dr. Asthana sir to give the closing remarks for this session. With your kind permission, Dr. Srivastava.
Respected DG sir, Professor Kaul sir, and all the dignitaries, because Kaul sir has a commitment, and thank you sir for accepting our invitation, because you have a busy schedule. Earlier we have spoken, but then also you have made your presence. Big thank you to you sir for coming and gracing this occasion, and thank you all the dignitaries who have come. Sir, my 2 points are there. I will not take 30 seconds. One was related to the unorganized sectors that must also be considered because the Ola and Uber driver, basically the drivers are concerned with the working hours. Our working hours start for the say about 8 hours or say about 6 hours or 10 hours. But they start early, say about 2 hours back, and after dropping us on our home, and they reaches to their home. So how we are going to consider their working hours? And secondly, this relate to the maid also. If we consider about this employment perspectives that we have the maid in our houses, without the maid, we cannot do our work. Maid is required. But as a human being, maid is also required the leaves. Then other things also, they should also be considered. Then ready wale, patri wale, these all main unorganized things also be considered. Sir.
New codes and domestic workers laws which are in the offing, I think they do take care of this unorganized sector, but it's not easy. One, to muster the support in the parliament.
Yes, sir.
And second is that there has to be a will with the government to, but I think the new codes which are coming,
Yes, sir.
they are at least in the matter of social security laws.
Yes, sir.
They are definitely making a strong case for them, and there is a provision already made for them.
Yes.
We agree that, that's what I said. The law that covers today is only 9%, maybe less than that. 91% are in the unorganized sector. But you will see that whenever cases have gone to the Supreme Court, after all, Supreme Court will deal only with the cases which come before it. Whenever cases of unorganized sector have also gone before the Supreme Court, court has been very sensitive to the problems of the, and this is Anganwadi workers he
Yes,
was
sir.
talking about today.
Ji.
Similarly, when we talk about rickshaw pullers cases, those are cases, but then how many cases go to the Supreme Court? At least I do not have the courage to fight out my battle. I always salute the workers who have the courage to stay up to long years to get justice and fight their cases in the Supreme Court. It needs a lot of courage, it needs a lot of finance, it needs a lot of support. But question is, we have to develop it in the form of a law. And for that, we need to have sensitive members of parliament.
Yes, sir.
And we need to have sensitive non-state actors working in these directions. I think law schools are a fertile ground for building that kind of a situation.
Thank you very much, sir. And thank you all for gracing this occasion. And tea is ready with us, sir, in the VIP lounge. Thank you all.
Thank you all. Now, I request you all to accompany us for the high tea at the mess, please.